Hello, everyone. Myself, Harmeet Saini, Register Migration Agent CECA from Melbourne office. Today, I am going to discuss a super sensitive and delicate topic, visa refusal and cancellations. Uh, Usually, visa refusal and cancellation is a very terrifying moment when somebody got notification from the department that they canceled or refused their visa application. And you've got panic and what to do after that, but still there is a hope. That's the main motive of this session. So if you got such notification and department state that you have 28 days to respond on such refusal or cancellation notification, or you need to depart Australia within a certain time, so you don't have to panic. So how to respond of these notifications and what to do after that, and what sort of options available to you. So you can contact your migration agent or our nearest CECA offices. Our offices are located all around Melbourne, all around Australia, like in Melbourne, Sydney, Perth, Adelaide, and Brisbane. So just contact our nearest office and we will guide you to go through such situations. So before going to start this topic, let us have a review on the last invitation round held previously, 189 invitation round. It held last week on 21st of August. On this invitation round, government give more priorities to construction sector, healthcare sector, and education sector. Let's go through some data of last invitation round, how the seat allocations, how the invitations were carried out. First of all, if you go through the construction sector, the construction occupations like bricklayer, carpenter, solid plaster, wall and floor tiler, roof plumber, electrician, they were invited at 65 points, which is the same point score as Australian government invited for the last financial year, the invitation round held in 2024. On the other hand, another occupation is painter. They invited this time on 70 points. However, they invited last year on 65 points. In healthcare sector, the occupations like audiologist, general practitioner, medical practitioner, registered nurses, midwife, physiotherapist, speech pathologist, these people were invited on 80 points compared to the level of 70 points last year. So there's a huge increase of 10 points in this financial year in such sector. In education sector, the early childhood teacher, secondary school teacher, special need teacher, and social worker, even university lecturers, they invited on 85 points. However, they invited 70 to 75 points last year in the last 2024 financial year. If we come to another sector like engineering occupations, like agriculture scientist, agriculture consultant, actuary, architect, chemical engineer, chemist, civil engineer, civil engineering draft person, construction project managers, management consultant, life scientist. These occupations, they invited on 90 points. There is still an increase of 5 points compared to the last financial year. And environmental consultant, and food technologists, they again invited on 95 points compared to 80 to 85 points last year. So this is the basic data how they invited this year, and as per these statistics, we can understand that government giving more priorities to construction worker. Uh, they still in demand, and government giving still high priority to these sectors in this financial year as well. On the other hand, not a good news for accountants and people working in hospitalities, uh, and even IT professional, ICT business analyst, IT uh, managers, software engineers, programmers, and other IT professionals. They were not invited on this last invitation round. But don't give up hope. So all these criteria change very frequently. So there is still invitation round 189 and 19491 still pending. So 19491 they be held soon after the seat allocations. Uh, and another 189 round government will conduct end of this year. Usually, as per their previous data, they conducts at least two invitation round in each financial year. Uh, Now, my advice for all of you is that if you guys are waiting for your invitation and lost your expression of interest, so please keep update all of your data. For example, your skill assessment, your English test, if you've done any professional year, if you've done any NATI, so everything must be updated, because whenever you got the invitation, so all of these data must be aligned with the point score what you're going to claim in your expression of interest. Otherwise, there would be the refusal of your visa application. So which is also the topic of our today's webinar. So let's start with this topic now. Let's come to visa refusal and cancellation. So if you have any question or anything, so our numbers are given there on the screen. So you can contact us or send your feedback, or you can ask any questions on this number, or you can even send us chat on the Facebook page as well. So let's start this chapter of visa cancellation and refusal. So usually today we're going to review why the visa got refused or cancelled, and after refusal, how to apply for the review with the ART, and about the deadlines, fee structure, and documentations for ART hearing, and what happens usually at the ART hearing and how to prepare for it. Let's start all these discussions. So first of all, I would like to explain the concept of visa refusal and cancellation. Some people got confused with these two terms. These are not the same terms. These are quite different. Usually, whenever you apply for a visa and you're waiting for the decision, and after certain time, when the decision come on your application and it is favorable, it is called visa grant. If it is unfavorable, means your visa application is refused. So the case officer is not satisfied the documentation you provided, or you have not compiled the criteria, no meeting the criteria of the visa grant. So that's why it is called visa refusal. On the other hand, visa cancellation is when you granted a certain visa and you already on that visa, but by any reason, department sees that visa, that you are no longer applicant to that visa, so it is seized. This situation is called visa cancellation. Usually if you are in Australia and your visa got cancelled, so it is not directly cancelled. So always whenever department going to cancel your visa, they send you the notification first that they're going to cancel your visa. They ask some comments, which is called notice of intention to cancel. If you reply accordingly, whatever information is asked, if department satisfied, they're not going to cancel your visa. But if they're not satisfied, then they cancel your visa. And if they cancel your visa, so you still don't have to panic. Still there is hope. You still have options available. So that's what the motive of this webinar today. Now, there are two criteria how the visa application got refused or cancelled. Usually, let's discuss with the visa refusal. So as I discussed, visa refusal usually happen when an applicant does not meet the visa criteria. Uh, Visa criteria I can explain you with one example. For example, uh, if you supply insufficient evidences of genuine relationship, you're applying for a partner visa. Even a lot of cases that come to me as well, people applied themselves the partner visa. They think they got married and they need to supply the marriage certificate, and that is the enough evidence to apply for a partner visa. So that is the biggest mistake. So you have to prove lot of documentations to confirm that your relationship is ongoing and genuine. So that's why on the lack of insufficient documentation, so case officer when not satisfied that your relationship is genuine, they usually refuse your visa application. Second example, I can say you are not, when applicant is not meeting the skill requirements. For example, in skill visas uh, cases, uh, if you apply, for example, employer sponsored visa, if you have to apply 482 visa, so the skill uh, or employment requirement is 1 year, and for direct entry 186 stream it is 3 years. So if you are not meeting such requirements, uh, not providing sufficient evidences to confirm that employment period, so in that case your visa application got refused. So on the other hand, visa cancellation, so it is done when visa is already granted to you and after the grant it is cancelled. So it usually cancelled when when there is a failure to maintain visa condition, or other reason is if there is a, if you fail to uh, in character or integrity concern. So you are not meeting the character requirements. In such cases, they refuse visa applications. Uh, there is one more thing I would like to discuss. Okay, my screen got jammed. Okay, all good. So the first reason, as I said, failure to maintain visa conditions. Uh, so when you check your visa grant notifications, on the top of it, there are certain conditions written on the visa grant letter. Uh, those condition, for example, the condition 8104, which says work limitations. Uh, like on your student visas, it is allowed 48 hours per fortnight. You can work in Australia on while on a student visa, uh, especially for the primary applicant. And if you got caught, the case officer come to know that you're working more than 48 hours per fortnight. So it means you are not meeting your visa condition, and it is the main cause for the visa cancellation. Second condition, which is quite common, 8202, you are not meeting the course requirement. You are not holding your CO, you are not enrolled in the course register course anymore. In that case, department send you the notification, notice of intention to cancel of your visa. Sometime gap is not too much. For example, your COI just cancel, and you are in the process of new enrollment and you got the COE and you supply to the department. If they satisfy it, so it you get saved. Otherwise, if your CO is cancelled from a significant time, so in that case, definitely you violating your visa condition A202, and your visa definitely got cancelled then. Another condition like 8501, maintain adequate health insurance. Most of the visas, either it's TR visa, either it is student visa, you have to maintain your health insurance accordingly. So even some people comes on visitor visa, especially the aged people or who are on longer stay like 6 months to 1 year. So department asked them to have the health insurance handy. They have to have health insurance when they come to Australia. It must be active. So as such condition, if you are not meeting these conditions, so department may cancel your granted visa as well. Another reason is the character ground. If you're not meeting the character requirements, such as breaching visa condition, failure character requirements, uh, for example, you get caught in some theft or you got any accident or something, a police case, you got convicted for any crime. So in such cases, or even you if you got jailed, so in that case, department may cancel your visa. Uh, Another third primary reason is if you provide bogus document. Suppose in the first glance you provided documents, department satisfied, they grant you the visa, but in the later stage when they come to know, or on the stage like you applying for some other visa, in that case department come to know that the documents you provided for your previous visa application, which is still active, they are bogus. So in that case they may cancel your visa granted to you. So these are the common criteria. There are a lot of another criteria as well, on the basis of which visa refusal and cancellation takes place. So these are the example to explain you how why the department give visa refusal and why they give visa cancellations um, on your granted visas. So whenever this situation happen, your visa got refused, your visa get cancelled, so what to do? So the next department come into picture after this situation is the ART. It is Administrative Review Tribunal. uh, Recently last year, from 14 October 2024, they changed this migration division name from AA to ART. So previously it was known for as Administrative uh, uh, Tribunal, and now it is Administrative Review Tribunal, which is ART. Even it was also known for its another name like MRT from a couple of years ago as well. Uh, so previously, when its name was MRT, and there was two division, they do the protection visa cases with the different department and normal visa decision with the different departments. So they have the two names. Then they merge these two names to AAT, Administrative Appeal Tribunal, and then last year they changed this division name to Administrative Review Tribunal. But it is the same body, same government body. Now ART, it is not the part of Department of Home Affairs. It is an independent body. They review the decision made by the Department of Home Affairs. So they deals all sort of decisions like migration or protection visa decisions or certain character related matters as well. Uh, the main role of ART is to a fresh review of the decision from Department of Home Affairs and considering whether it is legally correct and they give preferable outcome accordingly on their own merit on the basis of the documentation provided. So the key points when the visa refuse or cancellation takes place, which are reviewable by the ART, prescribed in the section 338 of the Migration Act 1958. The main requirements, if the your visa decision is reviewable, so you can appeal with the department ART. Then appeal must be lodged within a certain time limit. So ART has its own guidelines for the time limit as well, but they same as stated on the Department of Home Affairs decision. When you get any visa refusal or cancellation decision, so time limit is mentioned on that one. Uh, so these strict deadline have to follow. If you miss those time limit, then ART will not accept that case. So you can lodge ART by different ways. So the review application can be online or can be email, or you can apply in person to ART office as well. So or the online, it is www.art.gov.au, or you can send your forms, download the forms and send it to scan the forms and send it to reviews@art.gov.au. So it is quite expensive process. The fee structure for ART appeal is it is recently updated from the 1st of July 2025. So at present, the ART fee is 3,580 for review or cancellation decision. If the decision is related to protection visa, then its fee, there is no fee, but they charge $2,203 if you lose the case. And third, on general division, if the decision is related to character ground under section 501, so then the review fee is $1,148. On the top of it, you have to pay the charges if you're going with some immigration lawyer or migration agent. So agent fee also applied on the top of these fees. But there are some fee concessions available as well. So a 50% fee reduction may be requested if paying cause financial hardship. But for apply for financial hardship, you have to apply in writing on a certain forms. So first of all, you have to pay full or the reduced fee if it is accepted before the deadline. So submit a request for fee reduction form with the supporting documents. So the supporting documents, they may be the recent pay slips or Centrelink statements if you're getting any incentive from the Centrelink. Proof of other incomes, for example, if you're getting any child support payment or any investment payment coming into your bank account. If you're renting the property and your utility bills, your bank and credit card statements, uh, or evidence of any, if you have any evidence of fee waiver reduction from the organization, for example, legal aid or pro bono assistance, if you're getting help of these organizations. So all these supporting documents must be included with your application to support if you're going to claim 50% fee reduction in your review application with the ART. So when you apply, so ART may decide whatever information you supply to the ART. Otherwise, sometimes they give decision on that information what is supplied, but sometimes they may ask for further evidences as well. So be careful. It's always better to supply as much as information as you can before lodging the application. So as I said, there are So how the ART work? So usually, according to ART Code of Conduct, there is a practice direction assigned to the Administrative Review Tribunal. So new practice direction, this took effect on 23rd of October 2024, and those apply to any migration related decision, protection decision, or expedite character decision. So for example, if your visa got refused or cancelled on protect character basis, then it's processing time give more priority. Usually they finalize such application ART within 84 days or maximum to 3 months. So these guidelines are applicable to the applicant, the representative of the applicants, and to the tribunals, so that to ensure the fair, consistent, and timely review of the decisions. So as per the clause 1.3 of 2024 practice direction of ART, so these direction are applied, as I said, to migration protection and character related decision, but not applied to Section 501 character decision where the applicant is outside Australia at the time of application, uh, or protection visa refusal under Section 5H2, 36(1)(c), 36(2)(c) of the Migration Act. Some business skills visa decision, the decision under Section 136, or deportation decision when department decided to deport you under Section 200, or decision related to migration agents under Part 3 of the Act. So this direction not apply under these circumstances. They have their own regulations, but for the migration protection or expedited decisions, these are applied. Now, how to apply for the review? So general requirement when you apply for visa cancellation or visa review decision, to apply the review of the migration or protection decision, applicant must comply the Administrative Review Tribunal practice direction, as we discussed in the last slide, and Migration Act 1958 and Migration Regulation 1994. Strict compliance is required to prevent the application being declared invalid. So strict compliance, usually the main compliance is you must specify the exact reason for what you're going to review. You must supply the department decision that this is the decision, and it must be within the deadlines. So which is 28 days usually mentions on your visa decision notification, and ART guidelines as well. If it is within 28 days from the decision, then it is acceptable. But even if a single day is passed or single hour is passed, then ART is very strict, so your application will be invalid. Or second reason, if you have not paid the required fee, not get the confirmation of the reduction before applying, in that case your ART application will be invalid. So when you make a valid application with the ART, so you must include all prescribed information, must be accomplished by the all required documents, and the application fee as well. So all the information means, all the documentation means, for example, if your visa application is refused on the basis of genuine entrant decision, so you must supply all the documents with the review application that why you are not satisfied this decision, why you are genuine entrant, or suppose if it is not related, for example, if your visa decision on the basis that you have not studied or break the study in between, so you have to provide the evidences, what was the reason of that gap period, or even if you completed the subjects during that time, so just supply the transcripts or subject studied, the evidences of that, check with your institution and get the required evidences and supply with the application. So there are various ways you can lodge this application. As I discussed earlier, so you can apply online, you can apply on paper, or you can send apply via email. And next one is application fee, the reduction we already talked about. So uh, yeah, applicant involving family member, because most of the visa application, when family is also involved and they are the secondary applicant uh, of that visa application, and it is got refused or it is got cancelled. So in such cases, uh, usually what you do, you apply all together on a single application, but sometime by any chance your relationship broken and uh, your secondary applicant, they wish to apply separately for the ART review. So in that case, applicant must notify ART within 14 days of lodging a review if the family member has separate ongoing application for the same visa refusal and wish and or the wish to have applicant heard together, or but they must have written consent for all the parties. So you must notify the ART if there is a change in family members. Uh, so tribunal require written consent from each family member or the authorized representative before combining any application. Applicant must also notify ART in writing if the person included in the application wishes to remove and treat it separately. Other changes that must be reported after lodgement. A child is born and should be added to the application, or if relationship end or family member passed away, uh, or if it is the employer sponsorship application. So in that case, if the company is under administration, as administration changes, or it goes under liquidation or cease trading. So all these things have to be notified to the ART when you're lodging your application. So now the time limit, as I said, so time deadlines are very strict when applied to the ART. So there are different time limits applied to the different stages. For example, if the applicant is in immigration detention because of visa cancellation and he wants to apply to the ART, so he must apply within 7 days of being notified. If not in immigration detention, in that case, generally it is 28 days of being notified. So nowadays visa decision are notified by the email. Either they send email directly to you, or if you have representative and he applied the visa for you, uh, in that case they send the notification to the representative, and representative uh, transfer that notification to you. It is his responsibility to transfer that notification on the same day, because your 28 days will start from the day when department emailed that notification. And by email, that means that you have received that notification on the same day. So after that day, another 28 days is given to you to file the ART review of that decision. So again, I want to tell you, so these time limits are very strict. You can't request to extend this time limit. Nobody will extend, either the Department of Home Affairs or the ART. So you have to have apply this review within this time limit. And for character review application, there are 9 days to apply, and it is they prioritize such cases for the review, and tribunal must decide within 84 days. If you miss the deadline, definitely you will lose the chance for the review. So they will not consider your application anymore. In that case, you will have only one option left. You can go to the federal court. You can't apply to the ART directly. So now what happened when you apply to the ART? So till now we discussed when visa refusal or visa cancellation takes place and what the process after that. So how to file the review, what are the fee and charges, you adhere with the deadline of the ART. Now the next step is when you applied, what happened next? So department, after receiving that application with the ART, then department sent the tribunal the all relevant documentations, the decision record, the reason why the visa application was refused or cancelled. They supply all this information within 28 days of the review application being received. If it is confidential, you have the right, either you or the department may request the certain documentation or information not to share with the other party. Uh, for example, sensitive personal or security details. Uh, Requesting early access, if waiting 28 days cause hardship, you want to expedite the process, you can request early access by filing the request for order to shorten time for the lodging document form. So everything has to be in writing. And before lodging the documents with the ART, be careful. You have to submit as much as information related to that case, uh, and be careful by the missing evidences, uh, because this may be challenged at the hearing process. So now come to the hearing process at the time of hearing when ART open your case. Uh, so ART hearing is quite formal, uh, but less intimating than the courtroom. It is not like the courtroom, so only one tribunal member is there who makes the decision. During the hearing, first of all, the member explain the process and your rights. You represent or your representative present the evidences to the member. Even if you have any witness, so witness may give testimony. Tribunal may allow interpreter as well if requested. And when hearing starts, so member will ask question to clarify the facts. Both you and the department representative, if is present, can summarize your arguments. In terms of interpreters, so if you want interpreted for that hearing, so interpreter must be requested early in your response to hearing invitation. Uh, and please note, the interpreter only translate word for word, not summarize the words and not give the summarized meaning of what you want to state. So he just translate your wording. So speak clearly or slowly so that a translator not miss any important information. So when this hearing process going to start, usually first of all, they ask to swear and affirm to tell the truth. Now how to address the member, tribunal member. So you're not going to address like you address in the courtroom, your honor or something. So you address him as a member, or you can say member Smith. For example, Smith is a surname, so you can uh, have a with formal title like member Smith or senior member Brown or your honor if the member is a judge or president. So then when hearing starts, so tribunal member will ask direct questions. So be clear, don't panic, factual, and be concise. Do not interrupt or argue with the member. And interpreter, for non-English speaker, the interpreter translate every word. So that's why avoid long or complicated answers, so nothing to lost in translation. And representation, your migration lawyer or your migration agent can present your arguments and guide the process. And even if your representative is guiding your case, but still you may be asked the direct question by the member. Now, so at the end of the hearing, uh, there are possible outcome. There are three type of outcomes usually the ART members gives to you. So it is either favorable or either unfavorable or remit. So what these terms are, so if it is case in his own favor, so tribunal, it means that tribunal overturn department refusal or cancellation decision. So you may be guaranteed or keep your visa. So your visa will be granted to you if they overturn the decision. Second, if you are unlucky, it is unfavorable. It means tribunal affirm the department decision and your refusal or cancellation stand as it is. Third one is remit. If tribunal remit the case, it means this tribunal send case back to the department to reconsider with new directions. So, and they give this decision either orally and definitely they give you in written as well. So, if the oral decision is there after the hearing, it may be announced at the end of the hearing. And the return of that decision, the it written statement usually followed within 14 days and can longer as well for the complex cases. Now, the last option is if you still refuse that review application in the ART. Still, there is a hope. If you lose, so the still the option exists. You can appeal to the federal court on the point of law. Otherwise, if you eligible for any other visa, you still can apply another visa after that. And third option is you can request ministerial intervention, uh, but it is accepted in rare circumstances. So, but always and read the carefully the written reason given in your notification. They show why the tribunal decide against you or in your favor, whether further appeal is possible or not. So this is all about the ART process, how the ART decision takes place, how the ART hearing takes place, and what happened at the end of the ART decision. If you win after ART, good on you. But if you lose, there is a still hope. As I told you, still options available. You can apply to the federal court. You can go to ministerial intervention, or if eligible, you can apply another visa as well. So you have to check with your migration agent, and otherwise you can seek assistance from SICA migration offices as well. As I discussed, our office is located all major cities of Australia and even overseas as well. So any information you would like to know, please contact us. Our number is displayed at the end. And if you have any question, you can ask. Otherwise, I'm going to conclude this session. And please note our numbers and our email addresses. So if you have any question, just send it straight away. And for any further guidance, don't panic if it happens with you. If you lodge any visa application, if you need any assistance to review those applications as well, we're still here to guide you. If you're waiting for a visa decision for a long time and it is still pending, it is still in process, we still can help you to expedite those cases. So please do contact us, your nearest Sika office. Thank you very much for today.